received a call from an insurance company and they've asked you to give a recorded statement. There are a couple of possibilities of why they need a recorded statement. The first is that there's a question to liability. You got involved in like a T-bone accident and you say that your light was green, the other driver says their light is green, and they need a recorded statement. Now, depending on which insurance company is contacting you, you may be required to give that recorded statement. If the other party's insurance company is asking you for a recorded statement, you do not have to give it. And I would recommend that you not give a recorded statement. Anything you say to the insurance company can and will be used against you. So when they ask you questions about the accident themselves, they'll also ask you questions about your injuries. They'll ask you questions about what's going on. And they may, as some I've seen in some recorded statements, ask for personal information like your social security number, your date of birth, and phone numbers. This, along with a HIPAA authorization that they may have you sign as well, allows them to get access to all of your medical records, unless you limit them. And that's what we try to do here at Bressman Law, is help you protect your privacy. So if the other company's insurance company is, if the other party's insurance company has called you and they've asked for a recorded statement, say no, don't give it. Now, if your insurance company calls you and asks for a recorded statement, your policy most likely requires you to give the recorded statement. It's under the cooperation clause, where it says that if you're involved in an accident or there's potential litigation, that you will cooperate with your insurance company. Now, obviously, there are limitations to that cooperation, but if they're calling you asking for a statement because they're going to intercompany arbitration about property damage, you most likely have to give it. Now, intercompany arbitration is where, if you're in an at-fault accident where somebody else is at fault, and you would go through your own insurance company to get your property damage taken care of, one, you probably paid a $500, $1,000, $2,000 deductible on that, and you want your money back. But the insurance company, your insurance company, wants their money back too. So what they'll do if they can't come to an agreement with the other insurance company is they'll go to intercompany arbitration, and an arbitration officer will decide how much money your insurance company gets, and from that you'll get your deductible back and all of that. That does not affect your personal injury case. Even if the arbitration decision decides that it's 50-50, that does not affect and is not binding on your personal injury case. There's a lot more factors that go into a personal injury case that don't go into an arbitration decision. So this all goes back to the beginning recorded statement. When you give a recorded statement, that is forever recorded, as a recorded statement is supposed to be. So whatever you say in there, whether you know what to say or not, is going to be held against you. So if you say that you're fine, if they call you 2 days after the accident, they ask you for a recorded statement, and you say that you're fine, um, they're going to take you at your word. Even if you had been to the ER and at that moment you weren't feeling some of the pain that you were feeling before, they're going to say, well, you told us you were feeling okay. And they'll forever have that. It's the same reason why insurance companies will call you 2 days after the accident and offer you $1,000 and maybe up to $7,500 for your medical bills. And you don't know what your medical bills are going to cost. You don't know what your pain and suffering is going to be. That's where hiring a lawyer like somebody at Bressman Law is going to help you. So give Bressman Law a call if you've been in an auto accident at 614-538-1116, or you can email me at jedediah@bressmanlaw.com.